my name is Bridget Mackay. I'm an attorney in Petaluma, California. Welcome to my video blog. I'm going to talk about in this blog the question of, should I challenge a trust if I'm a beneficiary? So this is a situation in which you have learned that you are the beneficiary of a trust. Hopefully your trustee has sent you a notice that you have 120 days in which to challenge the terms of the trust, and hopefully you've gotten a copy of the trust and you've looked through it and you're unhappy with the way the terms of the trust go. You may have thought that you deserved more, or the person who died had promised you more, and you want to take the trustee to court. One thing I would caution you about first is many trusts have something called a no contest clause in them, which means that if you do contest the trust or the will, which is associated with the trust, then you can stand to lose anything you might have gotten under the trust. So if you were in the trust getting $10,000 and you thought you should get $100,000, you need to think about whether or not you want to challenge that to get your $10,000. The second thing is if you were challenging the terms of the trust, there's really only a few areas in which you can challenge it. If the person who wrote the trust was competent at the time that they wrote it, you're going to have a tough go of challenging the terms of the trust, even if they on their deathbed told you something different than what you eventually read in the trust. It's too late at that point. If that's what they felt, they should have changed the trust. But if you feel that they were not competent, not in their right mind, for whatever reason, under the influence of drugs or something else, or age or dementia, then you might have grounds for challenging the trust. The other area that is most common is challenging it under the guise of undue influence. So if you think there was someone out there when the person who died was making their trust that was putting some undue influence on them, in other words, talking them into giving them more, that person more, or giving it to someone else, then you might have a case. But the bottom line is if you're upset because you only got 10% of the trust compared to your brother or sister who got 90% of the trust, it's going to be difficult if you can't prove, or you don't have the evidence that the person who wrote the trust at the time didn't have some sort of incapacity or undue influence affecting them.